We want to file suit. Please provide your suit fee immediately. I get these inquiries all the time. Many times, this is the first contact I have with the client, with no information about the case or the debtor. The fact is that not all claims are candidates for litigation. Some creditors may find that the legal system in Mexico, with all its problems, may create challenges that makes the legal process debtor-friendly. This especially applies where creditors didn't document the loan or sale properly. The bottom line is that creditors should choose only the best claims for litigation and should put a game plan in place to reduce costs and risks. There are 3 issues that creditors should address before deciding to sue. 1. Cost and rewards. 2. Risks. And 3. Legal strategy. Costs and rewards. First, you must keep in mind that going into litigation has to make business sense. Spending $4,000 in legal costs for a $5,000 claim does not make sense. Despite this logic, some clients insist on suing even when it is unjustified. So, the first thing to do is determine the cost of litigation, which you do with your local attorney after reviewing supporting documents and identifying the legal strategy. Litigation in Mexico does not come cheap. This is because our legal system is inefficient. Every time you have an inefficient system, transaction costs are going to be high. According to the 2020 World Bank Guide on Doing Business, in Mexico it takes 341 days to get a judgment for enforcing a contract, while costing 33% of the value of the claim. While these numbers may not apply to all jurisdictions and every case, they are a good parameter. If I were to start litigation, I would discard small claims that have no collateral or security, as these may not justify the cost of good legal representation. Concentrate on claims that will pay off. Risks. Once a claim passes the test of cost and rewards, you must assess risks related to your action to determine the likelihood of success. 2 questions stand out: whether you will be able to seize assets from your debtor and whether you can win your case. Will you be able to execute if you win? You must make sure that the debtor has enough unencumbered assets that you can seize to pay your debt, and you must make sure that you will be able to execute against the debtor. These are different things. A debtor that has changed its company name creates a challenge. This could be fraud, which means that you will have to start a criminal case or investigation, which will add struggles. If the debtor is still there, you must confirm that he has enough assets to pay your debt. The debtor may have assets now, as well as a sound business, but what about in a year or 2 when you finish your case? A debtor with no market presence and no history will have no problem turning to fraud to protect its company and its assets. Is your debtor used to defending against lawsuits all the time? An investigation on lawsuits can tell you how big of an expert he is, which means higher risk. Do you have collateral, security, or a guarantee? When all factors are unfavorable, collateral may save your case. Will you be able to win your case? To execute, you must get a judgment, and fast. Different factors dictate how likely it is that your case will succeed. Ask yourself these questions. First, how strong is your case? The Mexican legal system relies heavily on documentary evidence. Do you have a contract, a promissory note, or an acknowledgement of debt from your debtor? Second, how good are the courts that will hear your case? The performance levels between federal and state courts vary greatly across Mexico. There are indexes that inform about the performance of courts. You should also ask your local lawyer to get a better insight. Third, what is the history of your debtor? If he has a history of lawsuits, he may be a greater threat. These debtors will easily deny the debt before a judge and may easily turn to fraud to protect their assets. Legal strategy. The key to success involves having a reliable lawyer that is willing to share the risk while having a sound action plan to control the cost and time of litigation. Local attorneys. Not only do you need a reliable lawyer, you need a lawyer that is the right fit for your collection case. You might have a trusted lawyer who specializes in contracts, but you should question whether he is the right fit to handle litigation and whether he will take your collection case enthusiastically. Another key factor is knowing the practices of local lawyers and securing a partner. The challenge is finding the right lawyer who is willing to share the risk by handling your collection case under contingency fees, at least partially. If the lawyer is just unwilling to work under a contingency fee, but not opposed to hourly fees, you should seriously question whether your case is a worthy candidate for litigation. Action plan. Good planning and follow-up helps tremendously in controlling things and raising your chances of success. You simply don't leave your case with your lawyer and turn your back. Ask your lawyer what type of case he will file, the challenges ahead, and the overall strategy pursued to win the case and collect. Try to gain a basic knowledge of legal issues involved. While you're not expected to become an expert, the effort to gain basic knowledge will pay dividends to understand your lawyer and set up the best strategy. Who makes the decision? In the movie The Rainmaker, attorney Danny DeVito is teaching the young lawyer Matt Damon the tricks of the trade. After Damon complains of that day's lesson being blatant ambulance chasing, DeVito objects. Who cares? There's a lot of lawyers out there. It's a marketplace. It's a competition. This scene illustrates our reality out there. Some lawyers will try to sell their services hard and will make recommendations for legal action when all facts point in another way. Don't get confused. While you're not a legal expert, it only takes knowledge of the issues raised here and good common sense to make a sound decision on whether to go legal. Have your lawyer provide all the information required, ask lots of questions, and then come up with a sound business decision of your own. Conclusion. Not all claims are candidates for litigation in Mexico. Be smart and avoid throwing good money after bad. Discard small claims that have no collateral and will not pay for good legal representation while returning a profit. In all other claims, do your due diligence to make sure that there are no unreasonable risks that will seriously put in jeopardy your collection or that will result in unreasonable delay or cost. Once you have found the good candidates, make sure that you find the right partner that will share at least some of the risk of litigation and put a game plan in place to reduce the remaining risk to the extent possible. Finally, keep good communication with your lawyer to make sure that your plan is on track and adjust whenever necessary. I invite you to share your comments or to call us for a free consultation. If you have any questions, please contact us at the numbers or email provided. If you would like further information about our firm or about our educational handouts, please visit us at hmhlegal.com.